All right. Hello and welcome everyone to the Captain Phoenix channel. Thanks for everyone who's coming in advance, to everyone who is going to be continuing to watch this show. Today we have a special episode. We're going to have guest as Mazlish on, and before we do that, we need to take care of just a brief bit of housekeeping before we start the meat of tonight's show. So first things first, if you have been following my company, Taylor Media, we are going to be making the move to MeWe, which is where you guys can follow me. So the link is in this video's description as to where you guys can follow me on MeWe now that I'm getting off completely of Facebook, and that includes my business, since I've been kind of held hostage by Zuckerberg here with my business. I'm moving off since I can't use the business. And that's because we do have a big announcement over at Taylor Media. We are moving to a new location, a bigger, brighter, better office. So all of this wonderful stuff you see behind me is going to be moving. So you'll see a completely different background moving forward, hopefully to be a great improvement. The other thing is, since you guys are watching on YouTube, I will be moving the channel to Odyssey. Hopefully I'm going to try to just start off by backing everything up on Odyssey. I'll have more information on that as time unfolds. And the other thing is that we are also going to have another event here, another special guest on at Sunday. That's the 24th, this Sunday at 8 p.m. Eastern. We're going to have a conversation with Marcus Ruiz Evans from Cal Exit, who's going to be presenting the case for secession, for the secession of California from the United States from a left-leaning perspective. So don't forget to check that out. I accidentally destroyed that video stream, so I'll have to rebuild that tomorrow. So more information to come. So lots of questions have arisen as a result of the past 2 weeks' moves away from the core tenets of free speech, which has brought us to some odd legal situations and which has brought up a ton of legal questions, especially related to antitrust law, which can get complicated and confusing quite quickly. So to help sort this out, I've brought in attorney Ed Mazlish with us, who some of you might know from the EGS show with the Liberty Block. You can find the Liberty Block at libertyblock.com, and you can find the EGS show on SoundCloud or iTunes by searching for the Liberty Block. So Ed, welcome.
Hi, Mike. Nice to be here. Thanks for inviting me.
I think we are having technical difficulties with our with Zoom. Let's see. Here we go.
Can you hear me now?
Yeah, yeah. Okay, here we go. Okay, sorry. It was just a technical difficulty with the video stream. So yeah, Ed, thanks for joining us.
Thanks for inviting me. It's a pleasure to be here, Mike.
All right, so we are going to have live Q&A at the end of all of this. Before we get to all of our questions for Ed, and again, I'll allow you guys to ask some questions too. We'll do that at the end. Ed, tell people a little about yourself and your background as an attorney.
I've been a practicing attorney for a little over 25 years. I started off doing constitutional law litigation, primarily in the area of the First Amendment. I've since broadened my practice out to commercial and business litigation, and I do a wide variety of things, from some of the anti-competitive stuff that you want to discuss today to just general business arrangements in general.
Cool. So with that, then let's get into our conversations. We're going to get to Parler's suit against AWS, but I want to start with something that's a little bit newer, because the precedent here is from a case from only about 2 years ago. So the question that I have been getting and have been seeing quite a bit is, based on the Second Circuit Court's ruling in 2018 on Trump's Twitter feed and how he can't block users from getting access to his Twitter feed, how is it that Jack Dorsey can now block users from getting access to Trump's Twitter feed by yeeting Donald Trump? Now, I realize he's no longer the president, but in the hypothetical situation where, say, he was president today, the question is, would there be grounds for filing, say, an injunction on Jack Dorsey to require him to continue to have Trump's Twitter account? So I guess we'll start off with what was the second court's ruling, and maybe you can expand on that and we can get our conversation started.
Well, just before I even get into the Second Circuit's ruling, I think the answer to that would be to your original question about whether Trump would have good grounds to seek an injunction to force himself back onto Twitter. I think the answer is no. And I think that the libertarian conservative universe is dealing with the issue of they're just a private company. And this is something that we've been talking about a lot on the EJS show that I've talked to you, that you mentioned earlier. If you're living in a purely free market, purely free, the Constitution only limits private government action, not private action. Jack Dorsey is acting as a private individual. The Second Circuit's opinion, as well, the original opinion, and then the denial of the hearing en banc, which en banc just means a rehearing by all judges on the circuit. The original hearing the original opinion was heard by 3 judges, which is the typical panel. The original, both the Second Circuit opinions go to great lengths explaining that Trump is a government official. He's acting in an official government capacity. They give a list of reasons explaining why he is acting in an official government capacity, including that his own Twitter feed or his own Twitter account identifies him as the president. He communicates official government positions through Twitter. He's communicated to foreign leaders through Twitter. The archivist of the United States has said that his communications are U.S. government property and have to be archived and preserved. And they gave a longer list. I'm not remembering everything they've mentioned off the top of my head, but they've said that he was acting in an official government capacity, and that in his official government capacity, he discriminated based on viewpoint when he tried to block people from receiving his messages and responding to them, and that as a government actor, he's not allowed to discriminate based on viewpoint, whereas Jack Dorsey, or Twitter generally, is a private company, a private individual that has the freedom to discriminate all at once. If I'm sitting in my house, I don't have to give you a microphone or a megaphone to come talk in my house. I can choose to hear you or not hear you. Or even a more realistic example, I can send a letter to the editor of the New York Times, the Washington Post. They can choose whether to publish it or not. I'm not entitled to get my opinion published just because I have a good thought on one of the New York Times or Washington Post stories. They're private companies. They can decide whether my letter to the editor or my opinion piece is published or not published because it's their property. As the president, the president doesn't have the same capacity or freedom to discriminate based on viewpoint. But on the other hand, just because you become president doesn't mean that you surrender your First Amendment rights either, which is part of why it's a tough case. It's not a simple and straightforward case, I don't think.
Which is why I wanted to bring it up, because there's a lot of what ifs involved here. So have you been able to find some cases that have cited the Second Court's decision as precedent?
I haven't looked into whether the Second Circuit opinions have been cited as precedent, but as I recall, they're pretty recent. It's only been
2 years.
I think they were handed,
Was 2018 was the decision made?
I think it was actually 2020 or 2019 or 2020.
Okay.
I'm thinking March of 2020, actually, by the time it got to the Second Circuit. Okay. I know the acts of blocking took place in 2017.
So maybe the case was initially filed in 2018 or something like that and just took that long to get heard by the second.
Yeah, the district court opinion might have been 2018.
Okay. So perhaps the reason we don't have precedent to expand upon what is actually meant here is just a matter of it being so recent.
Yeah. As I recall, the opinions did rely on a 2018 or 2017 Supreme Court decision involving North Carolina, which was the Packingham case. And that case dealt with a North Carolina statute that prohibited any registered sex offender from using a whole variety of social media platforms. And it was a very broad ban. It precluded them from using not just Facebook and Twitter and LinkedIn, but as the Supreme Court opinion in that case went through, it also prohibited them from using, say, Amazon, because there are customer review pages, and the customer review page allows interaction between the reviewers and people who were reading the reviews. And it also barred him from barred sex offenders from going on to the Washington Post or New York Times for the similar reason that you can interact with other users. And in that particular case, preventing sex offenders from being able to reach children was considered a substantial government interest, but the net that they cast was just too broad, and the statute was struck down. So that was the case that was cited by the Second Circuit, and Justice Kennedy wrote the main majority opinion.
So in this case, and I don't want to diverge too much from the topic of the Twitter discussion to begin with, which was, and I think you said it pretty succinctly, that the president's voice is basically the public square that you're talking about. And because Jack Dorsey isn't the president and he isn't the governing body, that public square that you referred to in the citation from the Second Circuit Court's opinion isn't something that Jack is creating. It's something that the president is creating. Am I getting this right?
I think that's basically what the Second Circuit said, yes, that the president created a public forum where he could interact with his constituents, whether they agree or disagree. And he invited comment by posting on Twitter. I'm not sure I agree with that, actually.
So you don't. So are you saying you're not sure you agree with the Second Circuit's opinion?
Well, it's a tough call. I don't categorically agree or disagree with it. The spirit of the opinion is to try and encourage robust debate. And I think that's a good thing. I think that's a good cultural value. I'm happy to see the courts trying to uphold that cultural value, especially given how under assault it is today, particularly, ironically, from people like Jack Dorsey and Twitter. But I think that the path they chose to get there, I think, is questionable. I don't think that just because Trump posts something on Twitter, that means that he's created a public forum. There was nothing in the opinions that mentions how often he engages people. He's just putting out information there. And to me, I analogize it in my head to, he can hold a rally at Madison Square Garden or any other public, brick and mortar venue. And if people came in and wanted to disagree with him, I don't think that there's any problem with him having the Secret Service remove people based on their viewpoint, based on the fact that they disagree with him. And he wants to communicate his message his way about official acts of public policy. I mean, if the president wants to talk about, sanctions on Iran or any other foreign, policy or any other domestic government policy, I think that he is entirely legitimate in being able to communicate it to his supporters, or just however limited way he wants to get his message out. And I don't think that Twitter changes that to me. And just if he blocks, to me, the block feature on Twitter is the equivalent of removing a heckler or removing someone from an in-person confrontation.
So, and we talked before in the show about this, that in the case of the issuance of a heckler's veto, I think you had intimated that it wouldn't even need to be a heckler's veto for him to have the right to excise that person from the room. It could be as simple as just carrying a sign that says that holds ostensibly just a neutral, not a neutral, but a political position with which he obviously disagrees.
I think that you don't lose your First Amendment right just because you become president. And if he wants to communicate a particular message, I don't think that the government has the power or properly has the power to force him to dilute that message by allowing people who disagree with him to be able to get on the camera with him, or to be seen with him, or to be heard with him. I think if he wants to get his message out, he has the right to get his message out his way. And if people want to engage him, they have to do it on his terms, I think. And in that sense, I think the Second Circuit got it wrong. But again, I think that they were trying, well, it's hard to say. I mean, if you just read it in a vacuum, they're trying, the opinion looks like the court was trying to promote more speech rather than less speech. And in that sense, I sort of applaud it. But I just don't think I agree with the path they chose to get there.
Okay, so basically, it sounds to me like this is confusing because it is confusing.
Well, cases that get to the Supreme Court generally have strong arguments on both sides. I mean, cases that are clearly in favor of one side rather than the other tend to not make it to the Supreme Court. So I'm not surprised that there's sort of arguments that go both ways. But that's what I think. I think that the president doesn't lose his First Amendment right to communicate his message, even insofar as, he's doing it on Twitter. I mean, I think, it's unfortunate that he's blocking people, but, it's very easy to avoid a block by just simply not offending him. And, you can still view his content, even if you're blocked. You log out of your account and you look at it on the internet.
Yeah.
And the court, the opinion actually referenced that, but the court said that was too much of a burden on the hecklers and
to log out of Twitter. Yeah. And
right.
Copy and paste. Yeah. Okay. All right. So it seemed like there's not much more to discuss on that case, which I kind of figured was going to be the situation here, where if, again, any hypothetical where Trump is still president today, if he were to file a suit or an injunction on Jack Dorsey based on the Second Circuit Court's opinion, you contend that it would probably not be the most meritorious of cases and would probably not succeed.
I would say that, but I would also say to your libertarian audience that I think this whole question of, they're just private companies is something that the libertarian community needs to address better, because right now the totalitarians are on the march. And if we don't do something to stop them, we're not going to have the ability to stop them before too long. And I'm not going to sit here and, it's beyond the scope of the show as we talked about, but even beyond that, I don't have the answer for sure right now, but I do know that whether it's antitrust enforcement or which we're going to get to, I guess, in a moment.
Just in a moment, yep.
Or other ways. I think that the whole they're just a private company is something that in a free market, not just in a free market situation, but when you have virtuous people that are not trying to undermine the system, I think that works better. But we're dealing right now with existential threats to our liberties, and we're dealing with actors who are working hand in hand with government. The social media companies are working very closely with the Chinese Communist Party to implement, perfect, and enforce censorship in that country. And I don't think they forget that knowledge when they come back here and create business policies here. When you look at all of our presidential administrations are hiring people from big tech companies, particularly the Obama administration, and Biden has already said he's got a whole bunch of people lined up to hire from the big tech companies. And it works the other way too. You have, I think, Schumer's chief of staff wound up taking an executive position, and other legislative assistants have taken executive positions with the social media companies. And it's not clear where the line between government action and private action is. I think we have to remember that fascism is nominal private ownership, but still government control. And if Chuck Schumer can call his former chief of staff and say, hey, look, it would be really great if Facebook blocked this person.
Yeah. So that actually segues into our next topic quite nicely, Ed, because it sounds like what you're talking about is collusive anti-competitive behavior. And my argument has been for some time that collusive anti-competitive behavior is not an element of a free market. And that's an appropriate place for a government to step in. And as much as I have some reservations about the Sherman Antitrust Act in general, I think that when it stepped in to basically say that collusive anti-competitive behavior is something that is not an element of a free market, and we are going to have government step in and restore mutual consent to all parties, because there are implicit parties to the transaction that have not offered their consent. When you have collusive anti-competitive behavior, And again, the topic that segues into nicely is Parler's suit of AWS, Amazon Web Services. As people probably know who have been watching my channel and who have come in from the EJS show and the Liberty Block know, Parler was not only given the boot from the Apple Store and iTunes, it lost its entire web hosting service, which means it is completely off the web for all intents and purposes as of right now. And it looks like it's going to come back up eventually here. But in the meantime, Parler has sued Amazon Web Services, and it sounds like it's going to be on grounds of Sherman antitrust. So, Ed, you want to give us a little bit of background in terms of the suit and its grounds?
Well, there's actually 3 counts in the complaint. The complaint details some of the anti-competitive and allegedly collusive behavior between Twitter and AWS, the Amazon Web Services. Those two are the conspiracy aimed at restraining trade for Parler. However, Twitter is not named as a defendant, which I find to be kind of curious because Twitter is the actual competitor. Twitter is the one that actually seems to be the one that's going to benefit from this. Or at least on the antitrust part of the action, Amazon's position is going to be that or Parler's position is going to be that there's no explanation for Amazon's action because there's nothing it's doing that's in Amazon's best interest, not short term, not long term. They're not looking to make any more money. They're not looking to lower prices for consumers. There's no pro-competitive or pro-profit reason for what they're doing. The only thing that explains what they're doing is that they're trying to give a monopolistic benefit to Twitter. And I think that sounds true. But I think it's going to be hard. It's going to be a case of first impression, I think, because Amazon is basically acting as a bully. Okay. They're not acting as a potential monopolist. They're just bullying for their friend. Usually the person who's the guilty person is the one who's trying to obtain a monopoly position and bury out its competitors. Amazon has nothing that it's trying to gain here. So I mean it's sort of akin to suppose that we decide, you said earlier in the broadcast tonight that you're leaving Facebook. I mean, suppose that there's a whole lot of us that are saying get off Facebook. It's
not safe grounds for your business anymore. And I agree with you, Ed. If you're a business owner, you should not be dealing with Facebook.
But here, those words are perfect. You should not be dealing with Facebook. Well, does Facebook then have a cause of action for conspiracy amongst all of us that are acting in parallel to refuse to deal with it? I'd say no. And because we don't have market power, we're not trying to obtain Facebook's market. And Amazon's going to make the same argument. They're going to make the same argument. So I wonder why Twitter wasn't included. I can speculate that maybe they thought there was a jurisdictional problem, that they didn't think they'd be able to get Twitter into a Washington court. But I don't know. I think it's a very curious omission, and it's the thing that concerns me the most. There are actually 3 counts in the complaint, though. It's not just an antitrust suit.
Well, real quick, what are they?
They claim breach of contract and breach of tortious interference with prospective advantage or contract. I forget exactly if they call it interference with tortious interference with contract or tortious interference with prospective advantage. The difference being whether there's an actual contract with the prospective party. Curiously, they don't mention the breach of the covenant of good faith and fair dealing, which is something that attaches to every contractual obligation in all 50 states, including the state of Washington. And I'll just say briefly that the covenant of good faith and fair dealing says that even if something is technically allowed by a contract, you cannot act in such a way as to frustrate the other person's expected benefit from the contract. You have to act in good faith. And they can make that argument. They've argued breach of contract. So because the implied covenant of good faith is a term implied in every contract, they can argue that later. But it's not actually mentioned in the suit. I hope that the attorney prosecuting it understands that. Um, the breach of contract action is simply that Parler says we didn't violate the terms of service. Um, and anyone who's dealt with these social media companies knows that they don't even disclose really what the breach of the terms of service generally is. Although in this particular case, the Amazon did send them various emails indicating that some of the posts on Parler allegedly incited violence. Whether that's true or not, I think is going to be a fact question. But those are the three counts: breach of contract, tortious interference with prospective advantage, and antitrust.
So before we get into antitrust, let's just touch real quickly on one question I have for you there. So is Parler alleging that that the terms of service with Amazon Web Services, the terms of service in the general, are an actual contract between the two parties?
Yes. They're saying that they didn't breach the terms of contract, the terms of service, and they're also saying that under those terms of service, they're supposed to have 30 days to cure any violation.
I see. Okay, so there was an actual specific grant within the terms of service that they are alleging has been breached by AWS, and not just that because they didn't breach the terms of service, unilaterally avoiding a contract is something that AWS isn't subject to.
Correct. They say that AWS's action violates a specific provision of the contract, namely that there's supposed to be a 30-day written notice of what the violation is, and that they have to have a chance to cure the violation.
Yeah, because that would bring us to a strange world where the moment somebody institutes a terms of service, unless there's an actual grant of the terms of service, like that 30 days notice, then anyone who gets the boot from any service who hasn't specifically violated the terms of service, to me, sounds like there might be some cause for suit. And you're suggesting, no, that's not the case. They're actually alleging a specific grant within the terms of service.
Well,
which is that 30 days notice.
As I said sort of a few minutes ago, every contract, whether it's written into the contract or not, contains an implied covenant, which is a promise of good faith and fair dealing. So if they just want to arbitrarily say you violated their terms of service and we're going to cancel your contract, they can't do that unless that action is in good faith.
I see.
Even if the contract gives them provision, even if the contract says we can terminate for whatever reason we want, they still have to act in good faith. They can't just do it because we feel like it. There has to be some reason that explains and justifies their action.
Sorry, so let's now move on to the antitrust case, because this seems to me to be the more the larger case, the more grandiose case, if we will, the claim that's being lobbied against AWS. So let's talk about what antitrust is, and let's give us your thoughts on what the grounds are, the legal grounds for the filing of the antitrust side of the cases in this situation.
Well, the claim is under the Sherman Act. The Sherman Act has two main provisions. They claim Section 1 has been violated. Section 1 deals with combinations, trusts, and conspiracies whose purpose is anti-competitive behavior. There are four elements. I've sort of mishmashed them together there, but the claim is that Twitter and AWS have gotten together, that they've entered a conspiracy to wrongfully kick Parler off the internet at a time when Parler is about to compete with Twitter and take a whole bunch of Twitter's market share because of all the people flocking from Twitter and Facebook, for that matter, to Parler based on the actions that Twitter and Facebook have been doing. And the claim is that there's a conspiracy, an agreement made between Twitter and AWS to kick Parler off the internet for the purpose of benefiting Twitter.
Okay, so has there been some precedent for a case like this, say, that is at least analogous to this case?
I'm not an expert in antitrust law. I should tell your audience that at the outset, but I do know enough to be able to comment. And as I said a little while ago, the interesting aspect of this case is that AWS doesn't seem to have any benefit from this combination or conspiracy. They're acting as a bully. There's no attempt to gain anything. And they're not being bullied by Twitter, right? If Twitter were saying to AWS, well, we're going to go to a different host unless you kick Parler off, then I could understand the claim. But I still would say that Twitter needs to be a defendant in the case, because Twitter would be the main culprit there.
So do you think not having Twitter as a defendant in the case hurts the case?
I think it does. I mean, I don't know how it's going to turn out, but that's the biggest flaw that I see. Maybe someone who's I haven't litigated an antitrust case, so I don't know if that's going to be a fatal defect in the filing, but I do see it as problematic. Go ahead.
Yeah. So in this case, we're alleging two separate things. One, that there is anti-competitive behavior, and two, that there is a collusive act towards that anti-competitive behavior. So what is the standard burden of proof before we get to the collusive side of things, just the anti-competitive behavior?
Well, there's a case from the mid 1980s. I think it's the Mazlish case. Basically, you have to show that there's no that the only explanation for the behavior, for the agreement, is an anti-competitive purpose.
Okay, so this could be inferred. So this could be inferred. We don't have to catch them on tape saying this is the purpose.
Correct. I mean, for example, if there are, let's just say that there are 4 gas stations on the same, street corner, and they all raise their prices at the same time and lower their prices at the same time. You may not have any written agreement. You may just have that they went to lunch 4 times a year, and they all agreed, when the first one raises his price, then we all follow. And when the other one lowers his price, we all follow. And, there may not be a phone call. There may not be an email. There may not be anything.
Okay.
That's called parallelism.
Oh, okay. Cool.
Conscious parallelism. So it can be inferred from circumstantial evidence. Obviously it's harder if it's circumstantial, but in this particular case, I don't see any other explanation that would explain it.
So
AWS hosts everybody.
All right. So in this case, before we get again to the collusive side of things, the burden of proof seems to be on AWS to prove that there is some sort of element to this that would promote competition. Am I reading that correctly? Because it sounds like what you're saying is that Parler is going to put their hands in the air and say, how on earth is this something that's going to in any way promote competitive behavior, promote competition in the marketplace? And the judge is going to turn to AWS and say, all right, let's hear your case. Am I reading this correctly?
I think yes, except from a legal perspective, you may not have said it exactly right. I don't know that the burden of proof is going to shift over to AWS to prove that it had a competitive purpose, but they will have to put forth some explanation.
Okay, some plausible deniability.
The burden of proof is always going to be on the plaintiff.
Okay.
They're the ones proving the case. Once they make their case that there's Parler has already alleged and is, I think, going to be able to prove, we don't see any competitive purpose for this conspiracy.
Okay, so now
for this action.
Yeah, and I don't either. And I think a fair-minded person is going to look at this and say, Parler, you better come up with like something plausible deniability, right?
AWS.
AWS is going to have to come up with some sort of plausible deniability on its face.
I would think so. Okay. I would think so.
And then on top of the anti-competitive behavior, there is another condition that needs to be met, which is the collusion side. So short of having actual videotape of somebody handing a briefcase of money over to an executive over at AWS saying, kick these guys, what is the standard of proof for the actual collusive behavior?
Um, as a lawyer, when the answer as a lawyer, the burden of proof is going to be that it's more likely than not that they were acting in concert and that they were acting for the purposes of harming Parler.
So what kind of evidence would Parler be presenting then in order to have a good chance at winning this case?
Well, they're going to present evidence that the kinds of inflammatory, allegedly violent speech that to which AWS objected on Parler existed on Twitter, and that AWS took no action against Twitter, hasn't threatened Twitter. Likewise with Facebook, that in fact most of the coordination that was done for the violence was done through those other two
through Facebook, actually
platforms, and that AWS hasn't taken any action against either of those platforms.
So that might just be, but that sounds like a unilateral favoritism. At what point do we have, what is the threshold for the burden of proof for the collusion side of things, where Twitter is basically in bed with the execs over at Amazon, and there's a favor that's going on here of some sort? What is the threshold for that?
You're raising the same issue that I raised earlier, which is that Twitter not being a defendant in the case seems like a problem for Parler. As it looks like to me, you're right. It looks almost like maybe this isn't collusive behavior. Maybe this is just Amazon being a bully and saying, I like Twitter, and just because I'm an asshole, I don't want Parler to succeed. I don't want Parler to take off. I want my friend to stay in business. I'm not going to benefit personally from it. I'm not trying to help anybody. I'm not trying to obtain any benefit, but I would rather see Twitter succeed. Now, I don't know. I can't tell you if that by itself is enough to violate the antitrust laws, because there's still, there's refusal to deal cases. But I think that in general, there has to be some benefit that the refusal to deal person is trying to achieve.
I see.
And it looks like AWS's action is purely destructive. There's no benefit to AWS at any point. And in fact, AWS loses all the money that Parler was going to be paying. And it doesn't seem like they're going to get that money back later. It's not like they're trying to drive a competitor out of business and then raise prices later. Well, that's not the facts here.
Well, any business can choose to do business with anyone else for any reason from a unilateral perspective. I thought that the problem with the collusion side of things is that when you're no longer responding to market influences. If Amazon refuses to do business, if a bake shop refuses to do business with gays and they go out of business as a result of it, that's on them. But if they call all the local bakers in town and say, don't serve the gays anymore, it seems like that's an entirely separate issue here.
Right. There's a case, I forget the name of the case, but it involved I think it was a radio station that took advertising, and it insisted that anyone who wanted to advertise on the radio couldn't also advertise in the newspaper, in the local town newspaper. And it had people that monitored, and if they found somebody who advertised in the newspaper, the radio station would cancel the advertising contract on the radio. And the purpose was to drive the newspaper's advertising revenue down and out of business, and force all the advertisers to deal exclusively with the radio station. That was a unilateral action. It was a refusal to deal, and that was found to be anti-competitive and a violation of the antitrust laws.
Interesting. So the collusive behavior isn't something that's necessary in order to succeed in filing a suit on the Sherman Act. Am I reading that correctly?
Yes, except it's not. That wouldn't be collusive behavior. That would be intent to monopolize behavior.
Okay.
And that's exactly what's missing in this case. AWS is not intending to monopolize anything.
Okay.
Twitter might be intending to monopolize.
I see.
But AWS isn't. So I'm not sure if this might be a sort of a case of first impression, which is lawyer talk for a new set of facts, a new case that never really has happened before, and the courts may have to deal with a novel situation.
All right. Well, before we get into our grander thoughts on the thing here, You did mention monopolize, and I was as Ed and I talked about before the show, I was reading in my business law textbook as a refresher of things, and there is a difference under the law between a monopoly and monopolization. Do you want to just briefly go over what that is, or intent to monopolize?
Right. Well, the intent to monopolize is some anti-competitive behavior. Um, it's not susceptible to a real easy uh, definition, because every attempt to succeed in business is an attempt to drive your competitors out of business. You want to win, and in fact, if you do anything to try and not win and keep your competitors in business, that's potentially violative of the antitrust laws as well. But as a general rule, from the what's called the rule of reason perspective, just purely successful business behavior is generally not a problem under the antitrust laws. The Alcoa aluminum case is an exception
Yep.
to that. They were basically punished for just being so successful that they drove everybody else out of the field.
Yep.
But the intent to monopolize usually involves some sort of bad act that's got its purpose in trying to restrain trade.
I see. Yeah. So one of the cases my textbook gave was in the case of a small market in a city. If you have a pro sports team that moves into that city and happens to have been the first mover and therefore realizes a first mover advantage, if it's too small of a market to basically provide funding for two different teams, then that's not monopolistic behavior. That's just realizing the first mover advantage. And if the New Orleans Saints happen to be the only major sport in New Orleans, just because New Orleans isn't that big of a city and can't really support two different franchises, that's not actually monopolistic behavior to move into New Orleans and be the only one in town.
Correct.
All right.
I think you have that right.
All right. So let's then talk about your overall thoughts on Parler's suit of AWS. Does it seem like Parler has a hope here?
I definitely think they have a hope. I think that it's clear to me that AWS and Twitter have either formally or more likely informally made an agreement to get Parler kicked off the internet. And the purpose of that agreement is to benefit Twitter and to further increase and maximize Twitter's stranglehold on that market. Twitter is a player with market power in that social media space. And to me, I don't see any other reasonable explanation to explain what's going on in that situation. I also think that if they argue breach of the implied covenant of good faith and fair dealing, Parler has a good chance of winning that claim, because I don't think that AWS is singling out Parler and ignoring Twitter and Facebook for the kind of conduct that they're using to justify their deplatforming. I don't think that's good faith. I don't think that they gave Parler an opportunity to cure. I think that Parler has a decent chance to win the case. My biggest concern, like I've said throughout this interview, is Twitter is the one with market power in this space. AWS is not a social media platform. Well, actually, under Section 230, they may be technically a platform, but Twitter is really the one with market power, and Twitter is the real competitor to Parler. AWS isn't really a competitor to Parler. So AWS looks like it's just acting like a bully, trying to do something nice for its friend. And that's the weak link in the chain that I see.
Okay. So if in the event that, say, Parler actually succeeds, what kind of precedent do you think this sets, and what do we see moving forward as a result of this?
That's a good question. I guess it depends on what the opinion says when it's written. I think as I said earlier, in the libertarian space, uh, we need to be wary of they're just private companies, but at the same time, we also have to be wary of forcing people to deal with you because, you know, at some point, if Parler wins, it's entirely possible that the people that are trying to put Parler out of business this way might try and just overwhelm Parler in another way. They might just go and send hundreds of thousands of people to troll and to make Parler an unhospitable place for the people that have tried to escape Twitter and Facebook, for
Yeah, and that's
example.
going to be virtually impossible to prove if that actually winds up being the case too. So
Yeah.
so Parler's recourse, I don't know, I don't even know what it would be if they did something like
Well,
that.
not only that, but what would before they get to recourse, at some point they're going to say, well, we need to be able to moderate our content. We need to be able
Yep.
to decide who we take on, and they're going to be, their hands might be bound by the decision that they got in this particular case. So, it's a difficult situation, and part of that difficulty is we're not dealing with reasonable differences of opinion. We're dealing with people that have a totalitarian mindset, and that at our and you know as I've said, under fascism, the private companies are the ones that implement the government policies.
Yeah.
And people tend to think of fascism as this strong arm dictator just telling companies what to do, but it works the other way as well. And that's,
Yeah.
it worked that way in Mussolini's
In
Italy,
Italy, yeah, yeah. Which is
where the
where the term actually comes from is fem fascii. In the late 19th century, fascism was viewed as basically a borderline anarchistic government in regards to economic regulation. So like laissez-faire taken to a straw man extreme. And what would happen is that the large businesses who were large enough to do so would establish de facto governments, and these small de facto governments that would dot Italy were the fascii. So that's actually where the term originates. So,
and that's sort of what's happening, I think. I mean, you've got people that get, like I said, get hired by the government. It's unclear to me who's the one calling the shots, honestly. And a lot of time, you can have informal conversations that are not legislation. It's one thing to introduce a bill or to vote on a bill, and then have the public evaluate that bill. But if there's a private phone call or there's a cocktail party in D.C. and the leaders of big tech are all attending, and you've got congressional leaders that are there, there's nobody who's recording and monitoring what's said behind those closed doors. And it's not like you have a congressional record for it. So it's not clear to me who's really the one, who's the senior partner and who's the junior partner in this relationship.
all right. So we've kind of gotten through, I think, as much of the legal side of things as we can without delving into kind of esoteric legalese. Ed, if you want to just give your final thoughts on all of this, I think you kind of did. I'm not sure if you wanted to just give a minute here while we get people a minute just to get some questions here up on Q&A. And then if you wanted to just give a shout out to the Liberty Block and to let people know how to reach you guys.
Sure. I think that the issue of our day, now that the Biden administration has taken power and the Democrats have both houses of Congress, is the creeping fascism that we're seeing in our country. We're not just seeing it in the big tech social media sphere. We're seeing it with COVID fascism and lockdowns and businesses being permanently locked down without just compensation being paid. We're seeing it in a lot of areas, being forced to put a muzzle over your mouth and nose. And I think that we need to be prepared to combat that. And we need to be thinking in terms of unorthodox ways of fighting back. Ordinarily, I wouldn't say I'm usually a proponent of the antitrust laws, but I think in this case with the social media companies, I'm all for it. I think that these companies have gotten into bed with totalitarian countries around the world, especially China, and they are carrying the water for dictatorship and for totalitarianism. And I think that we act at our peril by ceding the initiative to the bad guys when we say the market will take care of itself. Right now, it's very clear that the market has been co-opted by the totalitarians. And if we just let the market take us where it's going to go, right now it's going to take us to dictatorship. And we need to protect our rights and be willing to fight for what they're doing to us. And we need to be able to resist.
All right. Very cool. So Ed, thanks so much for joining us. I actually don't have any questions here in the Q&A. So folks, I'll give you just one more second to fire off in the comments section. Ed's here to answer all the legal questions that have arisen as a result of all of this. I guess I'll ask one question because I was on Matt Christensen's show last night, and he wanted me to ask you tonight about the burden of proof when it comes to the anti-competitive behavior side of things. And I guess I'll just ask it directly as directly as I can because I think we already discussed it. But when it comes to the not the collusive part, but the anti-competitive behavior, is the burden of proof in this case going to rest on Amazon to evidence at least, or to prove, or to make some defense of competitive behavior?
I think as I understand it, the Parler is going to have the initial burden of showing the anti-competitive effects. Okay. And AWS is then going to have to rebut it with some pro-competitive rationale.
I see. So the claim alone is not enough. However, it sounds like Parler's not going to have much work to do in order to evidence their claim, and then shift the burden of proof then onto Amazon in this situation.
It's not shifting the burden of proof, but it'll be shifting the burden of production. The burden of proof is always going to be on the plaintiff.
Okay.
Almost always going to remain with the plaintiff, but once they make what's called a prima facie showing,
okay,
then the defendant has to rebut that and give some explanation that justifies what he did.
Okay, so the bar here that needs to be met by Parler is a prima facie standard, which is, from what I understand, a fairly low bar.
I'd say it's a medium bar. I mean, a low bar would be allegations in a complaint. You can say anything in a complaint. You have to actually show proof once you get past the allegations of the complaint. Just merely making an allegation is not enough. But if you look at the allegations in their complaint, I think they're very likely to be able to show that this is an anti-competitive action, or at least presumptively anti-competitive action. And the burden is going to, AWS is going to need to rebut that by giving some explanation as to why it's not anti-competitive.
Interesting. So this is a little bit different, it sounds like, from burdens of proof in the criminal side of things.
Well, I mean, it's sort of, yes, it's definitely different than in a criminal situation. I mean, in a criminal case, the prosecution has the burden of proof of every element of the offense, and the burden of proof is not just more likely than not
a preponderance of the evidence, yeah,
right, which is preponderance of the evidence. In a criminal case, it's beyond a reasonable doubt, which means there can't be any other plausible explanation other than guilt for each of the elements of the crime. And then if the defendant then wants to claim an affirmative defense, like say self-defense, then the burden would be on him to prove his own affirmative defense. But that's a little bit different than what's going on here.
Oh, okay. So yeah, so there's not an actual affirmative defense. So I've actually read in certain general statutes, say in New York and Connecticut, where they have an explicit listing for an affirmative defense for certain charges, where there might be a statute that says this is not allowed, however an affirmative defense is.
Correct. And the defendant then has the burden of proof on the affirmative defense.
I see. Okay, that clears things up.
That burden of proof doesn't get triggered until the prosecution or the plaintiff, depending upon what you're talking about, meets his burden of proof in establishing the plaintiff or the prosecution's opening case.
All right. So Ed, we actually have a question here from HP Victory. Does AWS have a morals/ethical clause in the hosting contract? That's a good question.
I haven't read the contract. I don't know it. I would be surprised if Parler had violated it, though. Parler is
What do
not.
those terms usually look like?
Well, usually it prohibits uh, either party of the contract to do anything that'll bring the other into disrepute or show them in a bad light. And um, I don't see what, I don't think that Parler has done anything. And in fact, I think both sides actually have a Section 230 defense.
Interesting.
Parler would say, we're not responsible for what people are posting here.
Yeah.
Um, I think I think AWS is probably also going to say that Section 230 insulates them from
Eating.
antitrust action
Yeah.
and from whatever they do with their platform. They have the right to
Serve
pull.
whomever. Yep.
Right, they have the right, and they have the right to pull things down in their own judgment under
To
Section.
curate and censor to a certain extent. Yeah.
Correct. So I think I would expect both sides to argue 230 benefits them. We'll see, though.
All right. So if you have a minute, just on 230. So this is what we've actually talked about here when we're talking about 230 is retroactive curation versus proactive curation. So in the case of like the Daily Wire, their actual articles have been proactively curated, as in they don't get published until they go through the Daily Wire's editorial board, whereas the comments section gets published before it goes to the editorial board, and the editorial board then can retroactively curate that comment section.
Okay, well, what's the question?
Oh, okay. I'm sorry. Like, is that the distinction that people are failing to make here with the Section 230 questions that have come up as of late? The retroactive versus proactive curation.
I'm not aware of any of that being an issue. I think, it's way beyond the scope of what we're talking about.
Yeah,
But
it is. It is. Yeah. In
I think
fairness,
the
yeah.
horse is out of the barn on 230. I think if 230 got repealed, the effect would be, and I'll say parenthetically, I think it should be repealed. But I think at this point, repealing 230 would just lead to the censorship becoming stronger, and they would just they'd be much more careful about who they allow on their platform and who they don't, because at that point, then they're going to have a potential legal liability. So I think that the horse is out of the barn. They've already used the Section 230 protection to grow enormously, and they're out of control right now, honestly.
Okay. So that seems to have been the only question that has been raised. Folks, thank you so much for joining us. Ed, thanks so much for coming on.
Thanks for having me. And if anybody is interested in following us, as you said earlier, we're on the EJS show on the Liberty Block. You can find us on SoundCloud or iTunes. We usually record a Zoom on Wednesday afternoons at 4 o'clock Eastern. People who are interested in participating, you can contact the show. We have a page on MayWe. We had one on Facebook, but we've had some problems with that due to the censorship that we've talked about today. But reach out to us and we share the link, and you can send in questions or even participate by raising your hand and participating verbally the way you and I are talking right now. So I hope you enjoyed the show, and I appreciated being here.
All right. Sorry if we didn't get to your questions in time, everybody. And again, thanks for joining us. And now we'll see you in the next one. Good night, folks.